To become a licensed cosmetologist in the United States, you cannot simply pass a written exam. You have to put in the time. Depending on the jurisdiction, students are legally required to log anywhere from 1,000 to 1,500 clinical hours before they are permitted to touch a paying client as a licensed professional. This state-mandated time commitment has created a direct legal collision. State governments demand these extensive clinical hours to protect public health and safety, yet federal courts are actively penalizing beauty schools for letting students work those exact same hours unpaid. This visual matrix highlights the core of the problem. In 2020, this statutory collision resulted in a $2.8 million settlement in the case Eberline versus Douglas J. Holdings. The lawsuit exposed a massive gap between state educational mandates and federal labor compliance. For decades, school administrators operated under a very specific, flawed assumption. They believed that because clinical hours were mandated by state law, the school possessed blanket immunity from the Fair Labor Standards Act. If a student was logging time on the clinic floor, the logic went, they were learning, not working. Federal courts do not view a vocational curriculum as an indivisible shield against labor laws. When a beauty school operates its student clinic exactly like a high-volume commercial salon, the institution crosses a distinct line, triggering immediate federal liability for unpaid wages. Historically, beauty schools used a master-apprentice model. The clinic was purely educational, letting students practice on patrons under the strict watch of an instructor. Over the decades, that historical model warped into modern industry custom. Today, many student clinics are functionally indistinguishable from high-volume commercial salons. They accept daily walk-ins, push retail product sales, and actively incentivize fast turnaround times. The Fair Labor Standards Act establishes a strict baseline rule. Any individual who is suffered or permitted to work for an employer is entitled to minimum wage and overtime compensation. When an institution's custom prioritizes commercial speed and retail sales over educational safety, the clinic stops functioning as a classroom. It crosses the threshold from a protected vocational exemption into illegal, compensable employment. For years, the Department of Labor evaluated unpaid trainees using a rigid six-factor test. Modern appellate courts universally rejected that framework. Today, the Department of Labor aligns with the courts in using a flexible standard to assess the true economic reality of the student-school relationship. This diagram illustrates the primary beneficiary test. Originating from the Glatt decision in the Second Circuit, this test relies on 7 non-exhaustive factors to weigh whether the student or the school is receiving the most economic and educational value from the relationship. Factors 2 and 3 are critical for vocational schools. They demand that the trainee's work be tied strictly to a formal educational environment and actual academic credit. Factor 6 draws an absolute boundary. The trainee's work absolutely cannot displace the work of paid employees. A federal court applied this perfectly in a decision called Velarde. The court noted that because the cosmetology students worked exactly the 1,000 clinic hours required by New York state law to sit for their exam, and no more, the school was not exploiting them for extra labor. The students were definitively the primary beneficiaries, successfully mitigating the FLSA risk. When students perform tasks on the clinic floor that detach from their educational requirements, judicial scrutiny shifts. In the Eberline decision, the Sixth Circuit established the segmentation doctrine, a legal mandate for courts to slice a student's day apart, task by task. To categorize those tasks, courts look to the ultimate metric of vocational readiness, the licensing examination. The National Interstate Council exam strictly tests safe entry-level competency, infection control, and cross-contamination prevention. It does not test commercial speed, luxury customer experience, or advanced artistry. This establishes a protected green zone for beauty schools. Pedagogical tasks directly aligned with those exam parameters, like haircutting, mixing chemical formulas, and sanitizing personal workstations, are safe from federal wage claims. Then there is the red zone. This consists of repetitive, menial labor, completely devoid of tangible educational value that confers an immediate competitive advantage to the school. These are tasks that pierce the exemption entirely, managing the front reception desk, doing the facility-wide laundry, or sweeping the entire salon floor. When financial incentives cause a school to force students into this red zone to offset overhead costs, the economic reality flips. The school displaces paid janitorial staff. making the institution the primary beneficiary. Those specific hours immediately become compensable labor. Beyond federal labor law, high-volume clinics face a secondary layer of severe legal liability at the state level. To prevent beauty schools from acting as unfair commercial competitors against real salons, state legislatures enact strict pricing limitations on student clinics. This map highlights states like Pennsylvania and New Jersey, where statutes explicitly dictate that clinics can only charge the public a fee calculated to recoup the reasonable cost of materials used in the service. That specific phrasing triggered the Joachim class action lawsuit. Plaintiffs alleged that charging $12 for a student haircut far exceeded the actual $2 cost of the physical products used. The entire legal dispute hinged on ambiguity. Does the cost of materials strictly mean the chemical dye applied to the hair, or does it legally include facility overhead, water, and electricity? This discrepancy separates a high-risk, high-volume commercial clinic from an education-first model. A school that relies on public clinic revenue to pad its margins is exposed to this trap. An education-first model relies heavily on tuition rather than ambiguous clinic revenue, keeping its legal risk exceptionally low. State boards have generally hesitated to initiate formal rulemaking to strictly define what counts as overhead. This defers the problem to the courts, leaving revenue-driven schools highly vulnerable to predatory pricing litigation. Surviving the segmentation doctrine requires an immediate operational solution. Schools must audit all student tasks. If a student is performing clerical duties or janitorial work beyond the immediate sanitation of their own workstation, the school must hire paid staff to perform those duties. Transitioning practical hours away from live patrons and toward high-quality simulation eliminates commercial pressure. Executing chemical applications on mannequins isolates the educational benefit, removing both the incentive for commercial speed and the risk of cost of materials litigation entirely. Compliance requires strict verification. Schools must utilize accurate biometric tracking to cleanly separate instructional time from non-instructional breaks, generating an irrefutable record of exactly how a student's hours are spent. Finally, resetting consumer expectations is paramount. Using mandatory, explicit signage confirms to the public that the transaction is an educational simulation, not a commercial luxury. When patrons understand this baseline, the risk of complaints and regulatory friction is drastically reduced. State-mandated hours do not guarantee federal labor compliance. To survive the modern regulatory landscape, vocational schools must guarantee that the primary beneficiary of every single assigned task is definitively the student, not the institution's bottom line.